qualifications of the second respondent in their reply, and the petitioner have not joined issues with the second and third respondents in their reply to the second and third respondent reply. That a court of law adjudicates only on matters over which parties are in dispute. The DDG and Olosho and another Trade Bank PLC versus General of Nigeria Limited. Since there is no controversy or dispute between the parties as it relates to the second respondent educational qualifications, Exhibit RA10 is not relevant to determination of this petition, hereby discontinued. Our examination of Exhibits RA11 to RA16, which are data pages and visa pages in the second respondent Nigerian passport, show that contrary to the assertion of the petitioners that the documents are not relevant, the petitioners have alleged in paragraph 28 to 32 of the petition that the second respondent was fined $460,000 for an offense involving dishonesty, namely narcotics trafficking, and in response to this allegation, the second and third respondents have denied same in paragraph 46 to 53 of their reply, and specifically pleaded those documents in paragraph 52 of their reply to the petition to show that the second respondent enjoyed an unrestricted right of ingress and egress to the United States of America, and up till now, he still enjoys an unimpeded right of access to the United States of America. It is therefore our considered view that Exhibit RA11 and RA16 are relevant to these proceedings. Petitioner objection to them hereby discontinuance. As for Exhibits RA17 and RA18, the petitioner's reason for objecting to them has nothing to do with the admissibility of the documents. The second and third respondents, having raised objection to the first petition's locus standi to present the petition in paragraphs 1A to M of their reply to the petition. However, we have already considered and determined the issue of the petitioner's locus standi whilst resolving the respondents' preliminary objections. We have already resolved them in favor of the petitioners. Therefore, this objection has been overtaken by our ruling on the preliminary objection. On the petitioner contention that Exhibit RA19, the report of the committee on the location of the federal capital of Nigeria, is not relevant, we have examined the pleadings and the said exhibit. It is apparent to us that while the petitioners have averred in paragraph 81 of the petition that a presidential candidate must score 25% of the votes in FCT before he can be declared and returned elected, the second and third respondents have averred in paragraph 86 of their reply that the FCT does not enjoy a special status over the other states of the Federation, and that Abuja is still inhabited by Nigerians who are deemed equal to Nigerians in any other part of Nigeria, and residents of Abuja are not conferred with any privilege and advantage that is not accorded to citizens of other communities or states in Nigeria. We are therefore of the view that facts have been pleaded which renders Exhibit RA19 relevant and admissible. On the petitioner's objection to the admissibility of Exhibit RA22, we observe that the document is the same as Exhibit RA2, which we have already found to be admissible, having been certified by ANIC as a copy of document in their possession. Standard of Exhibit RA22, which is not even certified, is therefore a surplusage, hereby discontinuance. With regard to the objection to admissibility of Exhibits RA20 and RA25, which are CTCs of pages 28 and 29 and 27 of Nigeria Tribune newspapers, respectively. The reasons advanced for the objection of the petitioners are not legal grounds for challenging admissibility of a document. We have no hesitation in discounting the objection, contrary to the arguments of the second and third respondents' counsel that Exhibit RA27, the ECOWAS preliminary declaration, is a private document. The said document forms part of the official record of the Economic Community of West African States, ECOWAS, an official body established under the ECOWAS Treaty. An agreement made by member states of the ECOWAS community, and the treaty was signed by heads of states and government of the 16 member states. It's undoubtedly a public document within the meaning of Section 102 of the Evidence Act 2011. However, we observe that Exhibit RA27 is not certified as required by Section 104 of the Evidence Act to render same admissible. Not being so certified, Exhibit RA27 is hereby expunged from the record. As for the objection to Exhibit RA28 being the American Bar Association membership card of RW2, which was tendered by RW2 under cross-examination by the fourth respondent, it's clear to us that the document was neither pleaded nor listed or referred to in the statement of RW2, as rightly argued by the petitioners. Exhibit RA28 is inadmissible. Accordingly, it is hereby expunged record. Now we go to the merit of the petition. Having disposed of the various objections to witnesses and some of the documents tendered in the petition, we now proceed to consider the merit of the petition. The parties filed, exchanged, and adopted their final written addresses, starting with the respondents. The respective final addresses of the first, second, and third, and fourth respondent were filed on the 14th July 2023, respectively. On the 23rd of July 2023, 20th July 2023, and 23rd July 2023, the petitioners filed 3 separate final addresses in response to the final addresses of the first, second, and third, and fourth respondents, respectively. In reaction to the petitioners' final addresses, the first, second, and third and fourth respondents filed their reply addresses on 28th July 2023, 21st July 2023, and 28th July 2023, respectively. The first respondent and the second and third respondent also filed lists of additional authorities on the 28th and 31st of July 2023, respectively. On the 1st of August 2023, the parties adopted their respective final addresses. In his adopted final written address, Learned Senior Counsel for the first respondent, A.B. Mahmoud, SL, distilled the following 5 issues for determination. A, whether having regard to the provision of Section 131 and 137 of the Constitution of the Federal Republic of Nigeria 1999 as amended, and the evidence before the court, the second and third respondents were qualified to contest the presidential election 25th February 2023. B, having regard to Section 47, subsection 2 and 3 of the Electoral Act 2022, paragraph 38 and 92 of the regulations and guidelines for the conduct of the election 2022, the inability of the first respondent to transfer or transmit the results of the presidential election to the IRF portal real time. Amounted to non-compliance to Electoral Act, whether such non-compliance substantially affected the outcome of the election. C, whether by the totality of evidence adduced, the petitioners have proven that the election of the second respondent was invalid by reason of corrupt practices and non-compliance with the provisions of the Electoral Act 2022. D, whether in the absence of any proof of lawful and unlawful votes to be added to the scores of the petitioners and or unlawful votes to be deducted from the second respondent's scores at the election, the petitioners have proven that the second respondent was not elected by a majority of lawful votes cast. E, whether having regard to the declared results of the election and the provision of Section 134, subsection 2B of the Constitution of the Federal Republic of Nigeria 1999 as amended, the second respondent ought to have been returned as duly elected after having scored the highest number of votes cast with 25% of the votes cast in over 2/3 of the state's federation. The Learned Senior Advocate for the second and third respondents, Chief Wale Olanipekun, formulated the following 4 issues for determination. 1, having regard to the relevant provisions of the Constitution of the Federal Republic of Nigeria 1999 as amended, the salient provisions of the Electoral Act 2022, the judgment of the Federal High Court, and FC FAC ABJCS 1454-2022, Labour Party and INEC delivered on 23 January 2023, which is Exhibit X1, as well as admissible evidence on record, whether the election of the second respondent into the office of President of the Federal Republic of Nigeria on 25 February 2023 was not in substantial compliance with the principles and the provisions of the Electoral Act 2022. 2. In view of the clear provisions of the Constitution of the Federal Republic of Nigeria 1999, the Electoral Act 2022, and plethora of judicial precedents on the criteria for qualification of candidates for election to the office of President, coupled with the unreported decision of the Supreme Court in SC/CV/501/2023, People's Democratic Party vs. Independent National Electoral Commission, INEC, delivered on 26 May 2023, Exhibit RA23, whether the second and third respondents were or are not eminently qualified to contest the presidential election of 25 February 2023. 3. Upon a combined reading of sections 134 and 299, as well as other relevant sections of the Constitution of the Federal Republic of Nigeria 1999 as amended, Section 66 of the Electoral Act 2022 and other relevant statutes, whether the second respondent has not satisfied the necessary constitutional and statutory requirements to be declared winner of the presidential election of 25th February 2023 and returned as President of the Federal Republic of Nigeria. 4. Considering the constitutional petition and the task evidence adduced, whether this honorable court can accede to the reliefs being claimed by the petitioners. Prince L.O. Fabemi SN, Senior Counsel for the fourth respondent, also nominated 4 issues for termination as follows. 1. Whether having regard to the issues joined and the evidence led on the nomination of the third respondent as vice presidential candidate of the second respondent and the annulled civil forfeiture of the alleged civil forfeiture of the sum of $460,000 to the United States by order of the District Court in case number 93C4483, the petitioners have established that the second respondent was not qualified to contest the presidential election held on 25 February 2023 as provided for in the Constitution of the Federal Republic of Nigeria 1999 as altered. 2. Whether having regard to the relevant and admissible evidence led by the parties, the conduct of the presidential election held on 25 February 2023 election was vitiated by non-compliance that was substantial enough to have affected its outcome and justified nullification of the election as envisaged by the applicable provisions of the Electoral Act 2022. 3. Whether the burden of proving that first petitioner and not second petitioner scored majority of lawful votes cast in each of at least 2/3 of all states of the Federation and the Federal Capital Territory to be declared and returned as the winner of the presidential election held on 25 February 2023 has been discharged by the petitioners. 4. Whether having regard to the totality of the evidence led by the parties and the applicable law, the petitioners are entitled to succeed on any of the relief sought in the petition at all, or that the petition ought to be dismissed in favor of the respondent. On the part of the petitioners, their lead senior counsel, Dr. Levi Uzoku SN, distilled the following 3 issues in the petitioner's final address in response to the final address of the first and fourth respondents. 1. Whether the second and third respondents are qualified to contest the presidential election by reason of the unchallenged facts and circumstances arising under Section 137, subsection 1D, 142, subsection 1 and 2 of the 1999 Constitution, Section 35 of the Electoral Act 2023, this petition. 2. Whether from the documentary evidence before the Honorable Court read and examined together with the unchallenged expert and technical evidence of the petition witnesses, the petitioners proved that the non-compliance by the first respondent with the relevant provisions of the Electoral Act 2022 and the subsidiary legislation made thereunder substantially affected the outcome of the questioned presidential election held on 25 February 2023. So in response to the second and third respondent final address, the petitioners adopted issues 1 to 3 of the issues for determination with the earlier filed on 18th May 2023 during the pre-hearing session. These are: 1, whether the second respondent at the time of the presidential election held on 25th day of February 23 was not disqualified to contest the said election by virtue of the provisions section 1371D of the Constitution of the Federal Republic of Nigeria amended. 2, whether the third respondent at the time of the presidential election held on 25th February 2023 was qualified to contest the said election as the vice presidential candidate to the second respondent, and if answered in the negative, whether this did not invalidate the qualification of the second respondent to contest the said election. 3, whether the presidential election held on 25th February 2023, wherein the second respondent was declared and returned by the first respondent as the winner, was not invalid by reason of non-compliance with the provisions of the Electoral Act 2022 and any guidelines and regulations for the conduct of the election 2022 made pursuant to the Act. From the pleadings, the evidence adduced, and the submissions of counsel of the parties, it is a considered view that the following are the issues which will effectively determine this petition. 1, whether having regard to the provisions of Section 137 of the Constitution of the Federal Republic of Nigeria 99 as amended, Section 35 of the Electoral Act 2022, and the evidence before the court, the second and third respondents were qualified to contest the presidential election of 25th February 2023. 2, whether having regard to the evidence adduced by the parties, the petitioners have established that there was substantial non-compliance with the provisions of the Electoral Act 2022 and that the non-compliance substantially affected the results of the election. 3, whether from the totality of the evidence adduced, the petitioners have proven that the presidential election held on 25th February 2023 was invalid by reason of corrupt practices. 4, whether from the evidence adduced by the petitioners have established that the second respondent was not duly elected by a majority of lawful votes cast at the election. Well, we stated earlier, we have summarized the submissions of counsel. We didn't want it of reading them out. The first issue is whether, having regard to the provisions of Section 137 of the Constitution of the Federal Republic of Nigeria as amended, Section 35 of the Electoral Act, and the evidence before the court, the second and third respondents were qualified to contest the presidential election of 25th February 2023. Well, I think issue of qualification on this issue has been resolved in petition number 4. It's the same issue that has been raised here. So we stand by our resolution, this issue. The only exception is the allegation on the issue of the second allegation made by the petitioners in ground 1, which is contained in paragraphs 28 to 30 of the petition, is that the second respondent is disqualified from contesting the presidential election because they stated in paragraph 28 of the petition as follows. The Petitioner further pleaded that the second respondent was also at the time of the election not qualified to contest for election to the office of president, as he was fined the sum of $460,000 for an offense involving dishonesty, namely narcotics trafficking, imposed by the United States District Court, Northern District of Illinois, Eastern Division, in case number 93C4483 between United States of America plaintiff versus funds in account of 263226 held by First Heritage Bank in the name of Bola Tinubu. Funds in accounts 394833134, 394833396, 4650279566 held by Citibank NA in the name of Bola Tinubu or Compass Finance and Investment Company. Funds in accounts number that are held by Citibank International in the name of Bola Tinubu defendants. The petitioners have pleaded and relied on the order of the U.S. Court in Exhibit P5, which they tendered from the bar and which was subsequently identified by PW2 and PW12 in their evidence earlier summarized. The petitioners have centered their contention on the provisions of Section 137, subsection 1D of the 1999 Constitution, which reads as follows. A person shall not be qualified for election to the office of president if he is under a sentence of death imposed by any competent court of law or tribunal in Nigeria, or sentence of imprisonment or fine for any offense involving dishonesty or fraud by whatever name called, or for any other offense imposed by him by any court, tribunal, or substituted by a competent court, by a competent authority, or any other sentence imposed on him by such court or tribunal. A careful examination of the above provisions shows that the operative words of that paragraph of the section are sentence, imprisonment, or fine, and for any offense. Black's Law Dictionary, 6th edition, at page 1081, defines offense as, quote, a felony or a misdemeanor, a breach of the criminal laws, violation of law for which penalty is prescribed. The word offense, while sometimes used in various senses, generally implies a felony or a misdemeanor, infringing public as distinguished from mere private rights, as unpunishable under the criminal laws, though it may also include the violation of a criminal statute, which the remedy is merely a civil suit to recover the penalty, an act clearly prohibited by the lawful authority of the state, providing notice through public laws, close of court. Also, the Supreme Court, in the case of Abdullahi Umar and the state, held that an offense is an act which is clearly prohibited by law and which may be a crime or a civil offense. Sentence, on the other hand, has been defined by the same Black's Law Dictionary at page 1362 as follows. The judgment formally pronounced by the court or judge upon the defendant after his conviction in a criminal prosecution, imposing the punishment to be inflicted, usually in the form of a fine, incarceration, or probation. Again, this court also defined sentencing in Yakubu and the state as follows. The judicial determination of a legal sanction to be imposed on a person found guilty of an offense. It means the prescription of a particular punishment by a court to someone convicted of a crime. It is discernible from the above that the fine referred to in paragraph E of section 137(1) quoted above is one which emanates from a sentence for a criminal offense involving dishonesty or fraud. The words for imprisonment or fine also presupposes that the fine envisaged under the section is one which is imposed as an alternative to the imprisonment. In other words, the provision of section 137, subsection 1D relates to sentence of death or sentence of imprisonment or fine imposed as a result of a criminal trial conviction. Indeed, in considering the offense that can amount to disqualification under section 1371 of the Constitution, the Supreme Court held in Action Congress versus ANIC as follows. The disqualification in Section 137, subsection 1, clearly involves a deprivation of right and a presumption of guilt for embezzlement or fraud in derogation of the safeguards in Section 36, subsection 1 and 5 of the Constitution. The trial and conviction by a court is the only constitutionally permitted way to prove guilt, and therefore the only ground for the imposition of criminal punishment or penalty for the criminal offenses of embezzlement or fraud. Clearly, imposition of the penalty of disqualification for embezzlement or fraud solely on the basis of an indictment for those offenses by an administrative panel of inquiry implies a presumption of guilt, contrary to Section 36, subsection 5 of the Constitution of the Federal Republic of Nigeria 1999, whereas conviction for offenses and imposition of penalties and punishment are matters appertaining exclusively to judicial power. See also the cases of Amici and Anis Omuwaye versus Attorney General of a State, Abdul Karim and others versus Shinkafi. A careful perusal of P5 relied upon by the petitioners show that the case number 193 CV04483 was in the civil docket of the U.S. District Court, Northern District of Illinois, and it was a civil forfeiture proceeding against funds in specified accounts with First Heritage Bank and Citibank N.A. Exhibit N5 is actually an action in rem against the funds with First Heritage Bank and Citibank. It is not an action in personam against the second respondent. In Jonathan versus Federal Republic of Nigeria, citation supplied, the Supreme Court held in inter alia that Section 17 of the Advanced Fee Fraud and Other Related Offences Act 2006 provides for the power to make an order of forfeiture without conviction or for an offense, and that an order of forfeiture under the section shall not be based on conviction for an offense under the Act or any other law. The Apex Court further held that there was no need to prove any crime in forfeiture property under Section 17 of the Advanced Fee and Other Related Offences Act. A civil forfeiture is a unique remedy which rests on the legal fiction that the property, not the owner, is the target. Therefore, it does not require conviction or even a criminal charge against the owner, as it is not a punishment, nor is it for criminal purposes. See also the cases of Lawari Furnitures and Baths Limited versus Federal Republic of Nigeria, Alison Madueke versus ESCC. From the legal definitions and judicial authorities cited above, it is clear that the sentence of imprisonment or fine for any offense involving dishonesty or fraud envisaged in Section 137, subsection 1D of the Constitution is one imposed upon a criminal trial and conviction. In the instant case, the petitioners have failed to show evidence that the second respondent was indicted or charged or arraigned, tried and convicted, and was sentenced to any term of imprisonment or fine for any particular offense. On the part of the second and third respondents, they have contended that the second respondent was never fined for any offense and has no criminal record in the United States. In proof of their assertion, they have tendered exhibits RA8 and RA9 from the bar and called RW2 to give evidence and identify the said exhibits as documents he referred to in his adopted statement of oath of 12 April 2023. In paragraph 45 to 52 of his statement on oath, RW2 had stated that the second respondent was never convicted or fined for any criminal offense in the United States as alleged by the petitioner. In particular, RW2 stated as follows in paragraph 46, 47, and 49. 46 says, in case number 93C4483 at the United States District Court, Northern State District of Illinois, Eastern Division, which was pleaded by the petitioners. 1, no criminal charge was filed against the second respondent. 2, the second respondent was not arraigned and did not take or make a plea to any count in the charge of allegations of crime. 3, the second respondent did not go through a criminal trial. 4, the second respondent was not convicted of any crime or any criminal activity. 5, no sentence of imprisonment was imposed on the second respondent. 6, no sentence of fine was imposed on the second respondent. 7, no form of sentence was imposed on the second respondent. 8, case number 93C4483 was a civil suit in respect of which the court exercised civil jurisdiction under 18 U.S.C. 981 and 28 U.S.C. 1345 and 1355. In paragraph 47, he said, I also note that in case number 93C4483 at the United States District Court, Northern District of Illinois, Eastern Division, no impersonum criminal sentence was imposed on the second respondent. 49, the second respondent was not convicted in case number 93C4483, United States District Court, Northern District of Illinois. The United States of America, through its embassy in Nigeria, had, by a letter dated February 4, 2003, addressed to the then Inspector General of Police, confirmed that upon the record checks of the Federal Bureau of Investigation's National Crime Investigation Center, NCIC, the Centralized Information Center that maintains the record of every criminal arrest and conviction within the United States of America, there were no records of any form of criminal arrest, warrants against the second respondent. I shall rely upon a copy of the said letter of February 4, 2023, signed by Michael M. Bonner. Under cross-examination by the fourth respondent, RW2 has stated that as a practicing attorney in the United States, he knows that there cannot be a conviction unless there is an indictment. He also stated that exhibits RA8 and RA9 gave the second respondent a clean bill of health as far as criminal conviction is concerned. When cross-examined by the petitioner's counsel, RW2 has stated that the American court relied on Section 981 of the American Money Laundering Law, which is a civil, and not Section 982, which is criminal, and which the petitioner stated in their petition. He further stated that in the U.S., even a minor traffic infraction will be reported, so that if someone has a criminal record, the general record will show it. He added that a general search was conducted in respect of the second respondent. A look at exhibits RA8 and RA9 tendered by the second and third respondents showed that upon receipt of exhibits RA8 written by Nigeria's Inspector General of Police to the Consular General of the United States Embassy in Nigeria, inquiring of the criminal record of any of the second respondents, the U.S. Embassy had replied with the exhibit RA9 and stated as follows, quote, in relation to a letter dated February 3, 2003, reference number SR 3000, IGP SEC, ABJ, volume 24, 289, 87, regarding Governor Bola Ahmed Tinubu, a record check of the Federal Bureau of Investigation, National Crime Information Center, NCIC, was conducted. The results of the checks were negative for any criminal arrest records, warrants for Bola Ahmed Tinubu, POB 29, that's date of birth, March 1952. For information of your department, NCIC is a centralized information center that maintains the records of every criminal arrest and conviction within the United States and its territories. Apart from the above, Section 249 of the Evidence Act 2011 has stipulated how previous criminal conviction outside Nigeria can be established. Section 249, subsection 1 and 2 provides a previous conviction in a place outside Nigeria may be proved by the production of a certificate purporting to be given under the hand of a police officer in the country where the conviction was had, containing a copy of the sentence or order and the fingerprints of the person or photographs of the fingerprints of the person so convicted, together with evidence that the fingerprints of the person so convicted are those of the defendant. 2, a certificate given under subsection 1 of this section shall be prima facie evidence of all facts set out in it, without proof that the officer purporting to sign it did in fact sign it and was empowered to do so. It is instructed to observe that when cross-examined by the fourth respondent, PW1 had admitted that there was no certificate under the hand of a police officer in the United States of America where a crime was alleged to have been committed by the second respondent. It is significant to state that this petition is a declaratory action in which the petitioners are seeking inter alia that this court declare the second and third respondents as unqualified to contest the election. The petitioners who have made the allegation have the burden to prove the allegation on the strength of their own case and not on the weakness of the respondents. Okereke vs. Umahi, Menike vs. PDP, Omushore vs. Rebushola, Ucha and Elechi. The petitioners have evidently failed to establish the allegation that the second respondent is disqualified from contesting the presidential election under Section 137, subsection 1D of the 1999 Constitution because he was fined the sum of $460,000 by District Court, Northern District of Illinois. As shown above, the order of forfeiture in Exhibit PA5, on which the petitioners have relied, does not qualify as a sentence of fine for an offense involving dishonesty or fraud within the contemplation of Section 137 sub D of the 1999 Constitution. As regards whether paragraph E of Section 1, paragraph E of Section 137(1) will be read together with paragraph D of that subsection, the settled rule of interpretation of the Constitution or statute is that where the court is faced with two or more differing provisions over the same subject matter, the judicial attitude is to treat the special provision as overriding the general provision on the principle that by enacting a separate provision for a part of the general class intends that the said part shall not be treated the same with the general class. The Uguchuku, Nada versus Attorney General Anambra State, Martin Freuder and others versus Nejo and Co. Nigeria Limited, but FMBN versus Olo. Since in both paragraph D and E of Section 137, subsection 1, a sentence for the offense of involving dishonesty is mentioned, but in paragraph E, a limitation of 10 years has been introduced, then it means in respect of the sentence for offense of dishonesty, the two paragraphs must be read together, such that for conviction and sentence for an offense involving dishonesty, it must be within a period of less than 10 years before the date of the election, in order for such a conviction and sentence to be used for disqualifying a presidential candidate from contesting the election. It is also a cardinal principle of interpretation of the Constitution that relevant provisions must be read together and not disjointedly. The Abegunde and the State House of Assembly. From all the foregoing, it is clear that having regard to the provisions of Section 137 of the Constitution of Federal Republic of Nigeria 1999 as amended and the evidence laid before this court, the second respondent was not disqualified from contesting the presidential election held on 26 February 2023. Consequent issue 1 is hereby resolved against the petitioners and in favor of the respondent. Issue 2 is whether, having regard to the evidence adduced by the parties, the petitioners has established that there was substantial non-compliance with the provisions of the Electoral Act 2022 and that the non-compliance substantially affected the results of the election. Then we shall skip the submissions of counsel. Well, the appropriate starting point for the resolution of this issue is to first consider the objection of the first respondent to ground 2 of the petition, which they raised at preliminary stage, but which we deferred to this stage because it touches on the substance of the petition. The first respondent objection is that the petitioners are stopped from relitigating the issue contained in paragraph 2, paragraphs 33 to 79, as well as reliefs 5.1 and 2 of the petition, as is released to electronic transmission and collation of the election results, in view of the subsistent judgment of the Federal High Court in suit number FHC ABS CS 1454-2022, Labour Party Independent Electoral Commission, delivered 23rd January 2023. The certified two copies of which they attached to their petition as Exhibit A, and which was later tendered in evidence at trial as Exhibit X1. The first respondent particularly referred this court to paragraph 55 and 74 of the petition and submitted that the facts alleging non-compliance with the Electoral Act, which are set out in paragraph 33-79 of the petition, are hinged on the same issue of electronic transmission of results, which was resolved against the second petitioner in the said suit number FHC ABSC 1454-2022, to the effect that there is no mandatory requirement for the first respondent to electronically transmit results of the election. Reliance was placed on Bambegin and others was Oriare, Oyeroba, and another was Laupa. An examination of petitioner petition and Exhibit X1 shows that in their petition, specifically paragraph 37, 45, and 45, the petitioners have averred as follows. The petitioners aver that at the conclusion of the election and at each polling unit, the presiding officer was mandatorily required to electronically transfer the result of the polling unit directly to the collation system of the first respondent. In addition, the presiding officer was also mandatorily required to use the beavers to upload a scanned copy of the Form EC8A to the first respondent's result viewing portal, RF, in real time. 45, the petitioners aver that apart from the importance of the beavers in the capture of accreditation at polling unit in an election, the beavers is also mandatorily to be used in the process of uploading the information or data imputed into it by the first respondent's presiding officer at each polling unit, who shall, upon completion of voting and due recording and announcement of result, 1, electronically transmit the result of the polling unit directly to the collation system as prescribed by the first respondent. 2, use the beavers to upload or a scanned copy of the Form EC8A to the annual result viewing portal area as prescribed by the first respondent. And 3, take the beavers and the original copy of each of the forms in tamper-evident envelope to the registration area reward collection officer in the company of security agents. The polling agents may accompany the presiding officer to the registration area reward collection center. In Exhibit X1, the certified true copy of the judgment of the Federal High Court in suit number FHC ABJ CS 1454-2022 Supra, which the first respondent is contending to constitute estoppel to ground 2 of this petition. The sole question presented for determination in the originating summons is as follows. Whether, having regards to combined effect of sections 47.2, 52, 64, 65, and 62.1 and 2, and other relevant provisions of the Electoral Act 2022, the respondent can still insist on manual collation of results in the forthcoming general election. Upon determination of the above questions, the plaintiff, which is the second petitioner herein, sought for the following reliefs. 1, a declaration that the respondent has no power to opt for manual method other than electronic method provided for by the relevant provisions of the Electoral Act. 2, an order of this honorable court directing or compelling the respondent to comply with the Electoral Act 22 on electronic transmission of results in the forthcoming general election. In its judgment in Exhibit X1, the Federal High Court held as follows. In view of the foregoing, can the act of the defendant in collecting and transferring election results manually in the forthcoming 2023 general election be said to be contrary to the relevant provisions of the Electoral Act 2022? The answer can only be in the negative, as there is nowhere in the above cited section where the Commission or any of its agents is mandated to only use an electronic means in collecting or transferring of election results. If any, the Commission is only mandated to collect and transfer election results and number of accredited voters in a way or manner deemed by it. In view of the above, I'm finding that by the provision of sections 52 and 65 of the Electoral 2022, the correct interpretation of the said statute is that the defendant, Independent National Electoral Commission, is at liberty to prescribe the manner in which election results could be transmitted and are so whole. Consequently, this matter is hereby dismissed. Clause of court. It is tried law that for a judgment of a court to constitute estoppel in a subsequent action, it must have finally decided the same issue in contention between the same parties or their previous. The Anchorage Leisures Limited and others versus Eco Bank Nigeria Limited, and Adebayo versus Babalola and others. From the averments contained in the petitioner's petition, which I have earlier reproduced above, it is clear that the petitioner allegation of non-compliance averred in paragraph 2 of the petition is hinged on the contention that INEC was mandatorily required to electronically transmit or transfer the results of the polling units directly to the collation system of the first respondent, and also mandatorily required to use the beavers to upload a scanned copy of the Form EC8A to the first respondent result viewing portal, IRF, in real time. First, it is evident that in both this petition and in Exhibit X1, the parties are the same. In that second petitioner herein was the sole petitioner plaintiff in Exhibit X1, while the first respondent herein was the sole defendant in Exhibit X1. Secondly, from the above referred averments in this petition and the relief sought by the petitioner in in Exhibit X1, it is clear that the issue in both cases is whether the first respondent herein is mandatorily required to electronically transmit or transfer election results from the polling unit direct to the collation system. With the judgment of the Federal High Court in Exhibit X, the excerpt of which has been reproduced above, it is evident that the Federal High Court had decided the issue against the petitioners herein by holding that the first respondent cannot be compelled to electronically transmit election results. There is no evidence before this court that the second petitioner against whom the judgment in X1 was given has appealed against that decision. It is settled law that an appeal decision of the court remains subsisting, binding on the parties. The Abba versus Abba Aji, Jegede and INEC, Alexander and others versus Lone Star Drilling Company Limited. It is also tried that the doctrine of issue established is that where an issue has been decided by a competent court, the court will not allow it to be relegated by the same or different parties. It is also pertinent for us to state that in the final address of the first respondent, our attention was drawn to the recent decision of the Lagos Division of this court in appeal number CA/LAG/CV/332/2023, APC and Labour Party and 42 others, wherein this court set aside the decision in suit number FHC/L/CS/370/23, Labour Party and others versus ANEC. Another case, forum shopped by the second petitioner at the Lagos Division of the Federal High Court after losing at the Abuja Division of the same court in Exhibit X1. In the judgment in appeal number CA/LG/CV/332/2023, this court had upheld the decision of the Federal High Court in Exhibit X1 and construed same against the petitioners as issue estoppel in relation to the petitioner's contention, which they are making in this petition, that INEC is mandatorily required to electronically transmit election results. By virtue of Section 122, subsection 2 of the Evidence Act, this court is entitled to take judicial notice of the decision in appeal number CA/LG/CV/332/2023, APC versus Labour Party and 42 others. Not only that, this court is by the doctrine of precedent bound by that decision. Since the above judicial pronouncements have decided that under the Electoral Act and ordinary regulation guidelines for the conduct of elections, the first respondent cannot be compelled to electronically transmit election results, the petitioners are clearly stopped by those decisions from contending in ground 2 of this petition that the first respondent is mandatorily required to electronically transmit the election results to the election system. As a court of first instance, this petition, in this petition, we shall, notwithstanding our above finding, proceed to determine the merit of ground 2 of the petition relating to non-compliance. It is observed that in their petition, the petitioners have alleged the same set of facts in paragraph 33 to 79 as constituting both non-compliance and corrupt practice. On a careful perusal of the petition, however, it seems to us that to me that the allegations of non-compliance are contained in paragraph 33 to 56 and 59 of the petition, while specific allegations of corrupt practice were made in paragraph 60 to 78, even though same were also founded on the same facts of non-compliance alleged by the petitioners. The gravamen of the petitioner allegations of non-compliance are as encapsulated in paragraphs 37, 45, 50, 51, and 55 of the petition, which are reproduced below. I have produced. The respondents, particularly the first respondent, denied the allegations of non-compliance made by the petitioners in their respective replies to the petition. In particular, the first respondent denied that there was any collation system of the first respondent to which polling unit results were mandatorily required to be electronically transmitted or transferred directly by the presiding officer, and stated that the prescribed mode of collation of results is as stipulated in paragraph 50 to 55 of the regulations and guidelines for the conduct of elections. He further stated that the prescribed mode of collation was manual collation of the various forms EC8A, EC8B, EC8C, EC8D, and EC8E of the presidential election. See paragraph 31 of the first respondent's reply. He also stated that the BVAS is designed to upload the accreditation data at the end of the accreditation process, scan and transmit the result of the election at a polling unit through the e-transmission system, which is uploaded to the first respondent's result viewing portal, IREF. The first respondent further averred that the upload of data or images captured and automatically restored on the BVAS device requires data service, and where there is no such data service, where the service is poor, the BVAS service is designed to work offline, and the upload of data will occur when data service is available. He also stated that polling unit results were duly uploaded on the first respondent e-transmission system by the respective presiding officers at the end of the election, but some of the results were not visible on the RF portal due to the technical glitch experienced on the election day. In specific response to the petitioner's allegation of failure, refusal, and neglect to instantly transmit and upload the results electronically from the BVAS to the RF, the first respondent stated in paragraph 55, Romans 7 and 10 as follows. Immediately after the election of 25th February 2023, polling unit results were uploaded and received by the e-transmission system whilst using the BVAS. There was a temporary failure of communication between the e-transmission system and the IRF portal for the presidential election. In this regard, the e-transmission system returned an HTTP 500 error, which is an application error such that transmitted results, though received on the in-transmission application hosted on the AWS, the in-transmission could not organize and push the results instantly to the presidential module on the RF portal because it could not map the result uploaded for the presidential election to any state. The first respondent pleads and shall rely on the AWS CrowdTrail logs indicating patches deployed to fix the error of technical glitch on the election day. Upon resolution of the HTTP 500 error, the results which were delayed in the e-transmission system were eventually organized and pushed to the RF portal. The results are available as generated in their original form from the polling unit using the BVAS. The first respondent stated that the technical glitch did not in any way affect the result of the presidential election. However, in paragraph 37 of their reply to the first respondent reply, the petitioners denied that there was any technical glitch experienced on election day as contended by the first respondent, and stated that the failure of the first respondent to upload the presidential election results using the beavers to the average was a ploy to manipulate the actual results of the election. As indicated in their pleadings and submissions of counsel, the petitioner's allegation of non-compliance with the Electoral Act 2022 and the regulations and guidelines for the conduct of elections 22 is anchored on the provisions of sections 47.2, 61, 2 and 5, 64.4a and b, 64.5 and 73.2 of the Electoral Act, and paragraph 38.1 and 2, 48a, b, c, 55, Roman 5, 7 and 20, 51.2, 54.12 and 55.12, 93 of the regulations and guidelines. I have carefully considered the submissions of the parties on this issue of non-compliance with the Provisional Electoral Act and the paragraphs of the regulations and guidelines for the conduct of the election 2022. The Independent National Electoral Commission, the first respondent herein, is established by Section 153, subsection 1F of the Constitution of the Federal Republic of Nigeria 1999, and part of its functions as stated on paragraph 15 in Item F, Part 1 of the third schedule to the said Constitution, is to organize, undertake, and supervise elections, including election to the office of the President and Vice President, among other political officers listed. Being a creation of the Constitution, INEC is empowered by Section 160, subsection 1 of the Constitution to make its own rules or otherwise regulate its own procedure, and in so doing, it shall not be under the control of the President. Indeed, by Section 158, subsection 1 of the Constitution, INEC shall not be subject to direction or control of any authority person. By Section 4 of the 1999 Constitution, the legislative powers of the Federal Republic of Nigeria is vested in the National Assembly, which in the exercise of that power has enacted the Electoral Act 2022 to regulate the conduct of elections in the federal, state, and area councils of the Federal Capital Territory. Section 47, subsection 2 of the Electoral Act, relied upon by the petitioners, mandates every presiding officer to use a smart card reader or any other technological device that may be prescribed by the Commission for the accreditation of voters to verify, confirm, or authenticate the particulars of the intending voter in the manner prescribed by the Commission. Also, under Section 65 of the Act, the presiding officer shall transfer the results of the election, including the total number of accredited voters and the results of the ballot, in a manner as prescribed by the Commission. Section 62 sub 1 of the Act specifically provides that after the recording and announcement of the result, the presiding officer shall deliver same along with the election materials under security and accompanied by the candidates or their agents where available to such person as may be prescribed by the Commission. Further, Section 64.4 states that a collation officer or returning officer at an election shall collate and announce the results of an election subject to his or her verification and confirmation that A, number of accredited voters stated on the collected result are correct and consistent with the number of accredited voters recorded and transmitted directly from polling units under Section 47, subsection 2 of the Act, and B, the votes stated on the collected result are correct and consistent with the votes or results recorded and transmitted directly from the polling units under Section 60, subsection 4 of the Act. At this stage, it should be noted that Section 47, sub 2, referred to in Section 64.4a, relates to the procedure for accreditation of voters by the presiding officer using the technological device prescribed by the Commission. As for Section 64, referred to in Section 44b of the Act, it only mandates the presiding officer to count and announce the result at the polling unit. In fact, subsection 5 of Section 60 goes ahead to mandate the presiding officer to transfer the result, including total number of accredited voters and the results of the ballot in a manner prescribed by the Commission. The Act also provides in Section 64.5 that the collation officer or returning officer shall use the number of accredited voters recorded and transmitted directly from polling units under Section 47(2) of the Act, and the votes or results recorded and transmitted directly from polling units under Section 64 of the Act to collect and announce the result of an election if a collected result at his or her lower level of collection is not correct. From the aforementioned sections, it is clear that while subsection 4 of Section 64 provides for what the collation or return officer will use to verify and collect the results, subsection 5 also provides for what the collation or return officer will use to collect the results. Subsection 6 of the same section provides for what the collation or return officer will use to determine the correctness of disputed result where there is a dispute. These are A, the original of the disputed collected result for each polling unit where the election is disputed, which in our view means the physical or hard copy of the disputed result. B, the technological device used for accreditation of voters in each polling unit where the election is disputed. C, the data of accreditation recorded and transmitted directly from each polling unit where the election is disputed as prescribed under Section 47, subsection 2 of the Act. And D, the votes and result of the election recorded and transmitted directly from each polling unit where the election is disputed and as prescribed under Section 64, sub 4 of the Act, which requires only the counting and announcement of the result of the polling unit. A careful examination of the above sections, laid open by the petitioners, show that the Electoral Act had used the words deliver in Section 62, subsection 1, transfer in Section 60, subsection 5, and transmitted directly in Section 50, sub 2, 64, 4, 5, and 6 of the Electoral Act 2022, in stating how results of election should be handled under those provisions. A look at the definitions of those words in the Black's Law Dictionary 6th edition shows that the word transfer is defined at page 1497 as to convey or remove from one place, person, etc. to another, or to pass or hand over from one to another, or to specifically to change over the possession or control. The word transmit, on the other hand, is defined by the same law dictionary to mean to send or transfer from one person or place to another, or to communicate. In my view, the Electoral Act 2022 has used the words deliver, transfer, and transmitted directly, interchangeably, to describe how the results of the election shall be moved from one stage to another until the results are finally collected and declared. In all these, the Electoral Act 2022 has not specifically provided that the result of the election shall be electronically transmitted. It is in the exercise of its powers under Section 160, subsection 1 of the 1991 Constitution, and Section 148 of the Electoral Act 2022 that the first respondent does annex herein made the regulations and guidelines for the conduct of elections 2022, as well as annex manual for election officials 2023. In paragraphs 14A and 18A of the regulations, the first respondent prescribed the bimodal voter accreditation system, BVAS, as the technological device for the purpose of accreditation and verification of voters in the 2023 general election. The petitioners have also hinged their allegation of non-compliance on paragraph 38(1) and 2, 48A, B, C, 55 and 7 and 20, 51(2), 54(7), 55(7), and 93 of regulations and guidelines. Paragraph 38 of the regulation provides as follows. Extensive, get a copy of the guidelines, you will see here we have reproduced it in this judgment. From the foregoing provisions of the regulations and guidelines relied upon by the petitioners, it is clearly evident to me that although the Electoral Act has provided in Section 62, subsection 1, for the delivery by the presiding officer of the result along with other election materials under security and accompanied by candidates or their polling agents were available. Such a person as may be prescribed by the first respondent. The first respondent has, by paragraph 38 of the regulations and guidelines quoted above, introduced electronic transmission to a collation system, in addition to the physical transfer of the election results to the registration area of one collation officer. As stated earlier, the technological device as prescribed by ANIC in the conduct of the 2022 election is the bimodal voter accreditation system, BVAS. The function of the BVAS, as stated in paragraph 14A and 18A, is for verifying the voter through a positive identification of the voter and authentication of the voter by matching his or her fingerprints or facial recognition, thus accrediting the voter to vote at the election and storing the data and number of such accredited voters. By paragraph 38, 2 and 3 of the regulations, the BVAS is also to be used by the presiding officer to upload a scanned copy of the EC8A to the ANEC result viewing portal, IREF, after which the presiding officer shall take the BVAS and the original copy of each of the forms to the registration area from ward collation officer. From the above functions of the BVAS, it is clear to me that apart from using the BVAS to scan the physical copy of the polling unit results and upload same to the IREF, there is nothing in the regulation to show that the BVAS was meant to be used to electronically transmit or transfer the result of the polling unit direct to collation system. It should be noted that the ANEC results viewing portal, IREF, is not a collation system. The Supreme Court in Oyetola and ANEC 2023, ANEC 23 LPELR, has explained the difference between the collation system and the IREF. In that case, IGIM JSC held as follows court. As their names depict, the collation system and the ANEC result viewing portal are part of the collation process, the election process, and play particular roles in that process. The collation system is made of the centers where results are collected at various stages of the election. So the polling unit results transmitted to the collation system provides the relevant collation officer the means to verify a polling unit result as the need arises for the purpose of collation. The results transmitted to the result viewing portal is to give the public at large the opportunity to view the polling unit results on the election day. A community reading of the relevant provisions of the Electoral Act 2022, the regulations and guidelines for the conduct of elections 2022, and the ANEC manual for